everyone, I'm Sujit Ramchand. I'm an immigration attorney and a partner at Ramchand and Raval, where we've helped thousands of clients with their immigration matters. Today, we will discuss the top 5 issues to consider when preparing for the H1B process in 2022. We are soon coming upon the H1B lottery registration from March 1st to March 18th of 2022 for the 65,000 regular and the 20,000 US advanced degree H1B visas for fiscal year 2023. So here are the top 5 issues to consider when filing an H1B in 2022. Number 1, specialty occupation issues. To qualify for the H1B visa, the job must be a specialty occupation job. A simplified way of thinking of this is that the job should be the type of job that requires a bachelor's degree or higher in a specific field, such as a doctor's job requiring an MD degree, a lawyer's job requiring a JD degree, or a software developer's job requiring a bachelor's or higher degree in an IT-related field, such as computer science or software development. As far as specialty occupation is concerned, USCIS takes a very narrow view of specialty occupation. Therefore, an occupation that may be performed by degrees from multiple fields may not be considered a specialty occupation. So be cautious when drafting job duties and requirements. The LCA requires you to categorize the job based on a list of SOC occupations. Remember that the SOC occupation you select on the LCA should be one that is applicable to a specialty occupation. The job duties of the H1B position should be those of a specialty occupation and those applicable to the SOC occupation you select in the LCA. And although the job title is not controlling by itself, the job title of the H1B position should not conflict with the SOC occupation or the job duties of the position. For example, if you select the job title computer programmer and your SOC occupation is of a software developer, that may raise a few questions. If you have end client and vendors involved, ensure that their documents support the fact that the job is a specialty occupation. We sometimes find that these documents list different requirements than the petitioner for the same job or list multiple fields of degrees as acceptable. Number 2, availability of specialty occupation work at the petitioning company. The petitioner may be required to prove that the company actually has specialty occupation work available for the beneficiary to perform on H1B status. Especially for consulting companies, smaller employers, startup companies, or companies whose normal course of business is different from the specialty occupation work, such as a small doctor's office hiring a software developer. In these cases, the petitioner may need to prove that the petitioner has sufficient specialty occupation work for the beneficiary to perform on H1B status. Therefore, be prepared to provide one of the following: contracts and POs with vendors and end client and vendor letters, email confirmations from end clients and vendors, or proof of internal projects or products that require specialty occupation work. For example, in the case of the small doctor's office, they may be developing their own software or application for their patients to use and therefore need a software developer. So be prepared to prove that at the time of the filing of the H1B petition, you are able to establish that the prospective H1B specialty occupation work is available for the beneficiary to perform when their H1B status goes into effect. Number 3, LCA issues. It is very important to file the LCA correctly and thoughtfully. Otherwise, it could lead to a denial of the H1B petition or cause problems during the course of the H1B employment. Therefore, select the right SOC occupation. As discussed earlier, the SOC occupation should be one that is both applicable for a specialty occupation and is also appropriate for the job duties of the position. The work location is very important. It is important to list the correct work location. In addition, keep in mind that due to COVID-19, the beneficiary may need to work from home from time to time. Therefore, it may be prudent to also list the beneficiary's home address on the LCA. Picking the right wage level is very important. Please select the right wage level and pay the appropriate wages based on the job duties. For example, for a senior employee with supervisory duties, it would not be appropriate to pay wage level 1. Consider whether a part-time or a full-time LCA is appropriate. An H1B can indeed be filed for a part-time position, and in some cases, it may be appropriate to file an H1B petition for a range of part-time to full-time, such as 20 to 40 hours, to give maximum flexibility for business uncertainty. Number 4, beneficiary qualifications. The beneficiary must have a minimum of a bachelor's degree or the equivalent applicable to the specialty occupation job. If the beneficiary's relevant degree is from a foreign country, we recommend obtaining an evaluation acceptable by USCIS. If the beneficiary's academic background is unrelated to the specialty occupation job, we recommend obtaining an expert opinion using a combination of education and sufficient work experience that is acceptable by USCIS. You will need detailed work experience letters from former employers for this. Our website has samples you can access. If a license is required for a job, such as a pharmacist requiring a state license, then the beneficiary should meet the licensing requirements of the state where the beneficiary will work. The beneficiary's degree requirements must be completed before the filing of the H1B petition and not the H1B registration. Number 5, status issues. In order to file a change of status from within the US into H1B status, the beneficiary must currently maintain valid non-immigrant status. Most common issues related to maintaining status are, in case where the beneficiary has participated in CPT, the CPT must be related to the student's major, and the CPT has to be an integral part of the established curriculum. In case where the beneficiary has participated in OPT, the unemployment time by the beneficiary must be limited within the permitted limits. The OPT must be related to the beneficiary's major. Where the beneficiary has previously had L1 status, the work beneficiary has performed in L1 status may be important, and also the time the beneficiary has spent in L1 status may be important, as the time beneficiary spends in L1 status does impact the amount of H1B time that the beneficiary receives. Keep in mind that if beneficiary's OPT is expiring soon, then the H1B petition may need to be filed soon after selection, as in order to get CAP-GAP, the beneficiary's OPT must be valid at the time of the filing of the H1B petition. If the beneficiary has previously had F1 status, the beneficiary should maintain all of the I-20s, that pay statements on CPT OPT, get job verification letters from former employers on employer letterhead signed by an authorized person, showing time of employment, job titles, job duties, wages received, and also maintain proof of course attendance and course completion on F1 status. Please remember to collect your documents early and use checklists to avoid mistakes and delays. We've seen delays in clients trying to obtain documents from third parties during COVID, such as trying to obtain foreign college transcripts, trying to obtain expert opinions, and also trying to obtain work experience letters from former employers. So please request these documents early. Also, please anticipate delays at consulates for visa stamping due to COVID. Therefore, if time is of the essence, plan well and work with your lawyer to expedite the filing of your H1B petition and your DS 160 to minimize delays. If you need any checklists, samples, or further information, please feel free to contact us. I hope you found this helpful, and if so, hit like and subscribe below. Feel free to contact us if you have any questions related to the H1B process, or if you require legal representation with filing your H1B matter, and we will be happy to help you. Thank you.